Social media law in a few minutes. Tweets, retweets, TikTok short form user videos, online blogs, Facebook postings, Instagram images or digital video, YouTube and Vimeo, messaging, status notices, and emails copied and distributed to more than a second party that is beyond the traditional single mail correspondent can be libelous, breach of privacy, breach of copyright, and become unlawful publications in many dimensions of UK media law and, of course, in social media law. Throughout all UK legal jurisdictions, libel is a civil law issue in which the burden of proof is on the defendant, not the claimant. The construction of meaning in your communication has nothing to do with your intention and can be assessed by the most negative perception and by the most sensitive disposition imaginable. And so the risk of being considered potentially libelous can be very high in social media. Litigation is pursued by a privatized, profit-led legal profession. This operates with very high costs, and in most libel and breach of privacy cases, the legal costs substantially outrun any damages awarded by way of remedy. All social media communications are liable to other media law infringements, and these include criminal offences. The most serious risk is contempt of court and breaching reporting restrictions. There are cases in which people have been jailed. Social media users do not even have to name people to get into trouble, or even explicitly state or repeat an allegation. The former House of Commons Speaker's wife, Sally Bercow, was successfully sued for libel over one tweet when she asked why a former Tory politician was trending and added innocent face. This was deemed to be libel by jigsaw identification implication because allegations of child abuse had been broadcast by the BBC, and on the internet, somebody the BBC did not name was being identified in blogs and social media. Anonymity and alter ego identities will not protect people from the legal consequences of unlawful communications, as the UK courts have powers to order social media platforms, big tech, to provide the data leading to their identification. As communications on social media platforms are hosted by private companies and corporations, social media users are subject to terms and conditions contract law and can have their freedom of expression curtailed or deleted without any legal rights to restitution and return. Communications on electronic networks such as Twitter, Instagram, TikTok, and YouTube are liable under Section 127 of the 2003 Communications Act to criminal prosecution for any messages that are grossly offensive or of an indecent, obscene, or menacing character. Penalties on summary conviction at the magistrates' court can be as much as 6 months imprisonment and/or a fine of £5,000. In 2013, the Director of Public Prosecutions finalised guidelines on when it is not in the public interest to prosecute you. These were revised in 2018. Prosecutions are likely if social media communication contains a credible threat of violence, a targeted campaign of harassment against an individual, or which breaches court orders. The grossly offensive category is expected to be reserved for racial, gendered orientation, or hate crime abuse.